Hello, everybody. Thank you for joining us. This is the first of the Van Winkle Law Firm Business Group's series of presentations on business law. My name is Anderson Ellis. I'm an attorney with the Van Winkle Law Firm in our business practice group. Joining me today also is Meredith Silliman. She is an attorney also with our business group. We are very proud to be presenting this first in our 8-week series of business presentations. While all of these topics hopefully will benefit people who own businesses, some of the topics also will benefit those who are employees of businesses or people who are working in real estate. We hope that there's benefit both to business owners, business employees, and other people that are affiliated with businesses. Our presentation series comes after our Van Winkle Law Firm Trust and Estates group did a series of 16 presentations. If you want to find those, the various topics that they covered last year, you can find them on our Van Winkle Law Firm Facebook page or on our YouTube page. So please, go find those and find out what the Trust and Estates group was talking about last year. Because we are a law firm and we can't do anything without the disclaimer, I will say that this presentation is not intended to be specific legal advice. It is based on our experiences with North Carolina and federal law. If you have specific questions about your business or about the business for which you work, you should contact your employee or your attorney, your company's attorney. Certainly, the Van Winkle Law Firm is available if you don't have an attorney and you want to talk. But as far as questions that go into our chat or other questions that we'll address in this presentation, this is not intended to be any specific advice in any specific circumstance. So with that being said, Meredith, we're going to talk today about contracts. So why don't we start off with just a little bit of introduction for everybody about the life cycle of a contract. Where does it start?
Great. So we want to make sure you understand that before you have a piece of paper in front of you that you call a contract, there are some things that may happen first. So usually when people want to enter into a contract, there are two different parties. Either one may indicate sort of interest or a need. Generally, that starts negotiation that will eventually end in a contract. We are hopeful that your contract will be in writing. As Anderson will talk to us about a little bit later, certain contracts do have to be in writing, but we always recommend that contracts be in writing, regardless of whether that's required. Once you've got something in writing, there may still be further negotiation before the contract is actually signed and effective. So we want to talk a little bit about the in-between. So a lot of times people call an attorney and say, hey, will you help me review this contract? Or will you negotiate this contract for me? So there's a difference between the two of those things. Reviewing a contract in and of itself is useful. You can have an attorney walk through and explain what the terms mean, what you're allowed to do or required to do, and what you're prohibited from doing under a contract. As we'll talk about a little bit later, defined terms are really important, and that's something that someone can help you understand in a review. Negotiation, on the other hand, is actually intended to help you get terms that are more favorable to you in the contract. So at that point, an attorney will not only tell you what the contract says, but should give you some advice about places that you may want to consider negotiating different terms. When we talk about, when to get an attorney involved with review or negotiation, it may seem counterintuitive to say get someone involved early, but in many cases, getting an attorney involved early in the process will actually save you money. If terms have already been negotiated, if one party is very entrenched in a certain position, it takes a lot more effort to get things changed than if you just start with an attorney. When we talk about starting with an attorney, we want to talk about there are a few differences there too. So one example is you may have a letter of intent that you negotiate prior to negotiating an actual contract. And a letter of intent, you're probably going to want to get an attorney involved so that you understand which of the terms in this generally non-binding agreement might be binding. You may want help negotiating those terms before they're agreed upon. On the other hand, if you're entering into a services contract, you may want to wait until the other party provides you with a form. So a lot of times if there's a contract that people use frequently, if there is a services company that provides the same service to every single customer, it might be in their best interest to develop a form contract that they use for that purpose. The benefit of receiving a form contract is that you have a little bit less work. You're not having to prepare a contract. However, we do want to flag for you that when you receive a form contract, it's typically more one-sided than if you've negotiated a contract together. The terms are going to be more favorable to the party drafting the contract in most cases. The good thing is you can negotiate and draft your own form contracts for your use. So we want to talk about sort of what you need to actually result in having a contract now that we've talked about the process a little bit. Anderson, can you help us with that?
Sure. So the first thing that you need to understand is there are certain elements of every contract that have to exist in order for there to be a binding contract. The primary one of those elements is mutual assent. It's the offer and acceptance, the meeting of the minds, so to speak, between the parties of the contract. They have to understand what they're negotiating and what they're getting and what the terms are. That's the very basic building block of a contract. There has to be consideration. Consideration is a legal term of art, but it means each party has to get something. They have to be obtaining something or potentially giving up something in order for there to be a binding contract. You cannot have a contract where somebody is agreeing to do or not do something and they're not getting anything in return. So you have to have that. It might be money. In a services or a purchase contract, there might be money exchanged for a good. You might also, like I said, be giving up something like a restrictive covenant, which we'll talk about later. You might actually be giving up your rights to do something that you have a legal right to do in exchange for whatever you're getting. A settlement agreement would be a good example of that too, where you're actually giving up the right to proceed with a lawsuit in exchange for something that you're getting. So that consideration for both parties has to be present. You also have to have capacity. Each person involved in the contract has to have the legal ability to enter into the contract. The places where you might look for that would be very elderly people who may or may not have all of their mental faculties, people who have other mental ailments or disabilities that might prevent them from understanding what's in the contract, or people who are very young who don't have the legal capacity, even if they have the mental capacity, to enter into a contract. That age might be 16, 17, 18. It depends on what kind of contract it is. But as you're dealing with folks in that age range, you need to be careful that you're not entering into a contract that by its own definition would be void no matter what and unenforceable. You also want to make sure that the person who is entering into the contract has the authority to do it, particularly if you're dealing with an entity, an LLC or a corporation. If somebody's signing as the manager or the president, you want to make sure that they're actually that person who has the authority to bind the company. So you want to make sure they have capacity, legal, mental capacity. And speaking specifically about legality, there is a difference that I want to distinguish between something that is illegal versus something that is vague. So if you have a contract that has particular terms, even if those terms are very confusing, you have to be careful, because when you sign your name to a contract, the court, if that's where you end up to enforce it, is going to assume that you understood what you are signing. You are not going to be able typically to go into court and say, well, I didn't understand it. It was too complicated. There were big words that I didn't understand. I didn't know what I was signing. They're going to assume if you signed it that you understood. This goes back to Meredith's first point about when to get a lawyer involved. If you're dealing with a document that you don't understand, you need to speak with someone who can explain it to you, because odds are it's not going to be unenforceable simply because you didn't understand it. Now, there is a difference there between, vague or complicated and illegal. If the contents of the contract are against public policy in some way, for example, a murder for hire contract, if someone was foolish enough to put that into writing, might be something that is just not enforceable. Even if every other element of a contract is present, it's not going to be enforceable because it's clearly illegal. It's against public policy. So if you have something like that where you're worried about what the contract says or how it says it, it might be time to consult with an attorney to learn what that contract says. And what Meredith was talking about earlier, contracts that have to be in writing, there is something called the statute of frauds. Statute of frauds is a list of different contracts that have to be in writing, or they just simply can't be enforceable. Some examples of that would be contracts where performance of the contract, it takes longer than 1 year. So a multi-year contract of some sort of lease or a service agreement. The sale of real property or land, that's going to need to be in writing in order to be enforced. You can't have a verbal contract for the sale of property. Goods over $500, so big goods contracts, and things where marriage is the consideration, where one party is agreeing to marry somebody in exchange for something, which typically you'd see that as like a prenup. Or a post-nup, I suppose, but something like that, a prenuptial agreement where someone's agreeing to be married in exchange for some sort of benefit down the road. Those kind of things have to be in writing. So again, if you're dealing in one of those areas, or you're just not sure whether what you're doing has to be in writing, and maybe the other side is saying, oh, no, don't worry about it. We can do this on a handshake. You might want to talk to a lawyer and see if that really is the case, because you don't want to be in a situation where you've shaken hands and you've agreed on the terms of a deal, but it's one of those prohibited categories where it just can't be oral. Meredith, well, let me talk first. Before we move on, there is one element of a contract that we get a lot of questions about. That is a default. What is a default in a contract? Very basically, a default is a breach. It's when someone doesn't follow through with the terms of the contract that they are supposed to follow through on. What results from that breach depends on the language of the contract. If that breach allows the non-breaching party to terminate the contract, or maybe it entitles them to monetary damages or something else, that is a place where negotiating those terms into your contract could really be of benefit to you. If you are the person who is to receive a benefit and you are very concerned, if I don't receive this benefit, there's going to be a lot of detriment, a lot of damage to my business or to me personally, you want to make sure you have a good, strong default clause that gives you rights in case the other side doesn't follow through. So you need to understand what rights you're going to gain if there is that default. Now, on the flip side, you also want to know what is a breach. If you're the person who is providing those services or providing the goods, you want to know what constitutes a breach and what rights you may have to fix that breach. If push comes to shove and you can't follow through with what you're supposed to do, do you have 10 days to cure it? Do you have to receive a written notice of your default from the other party before it's actually a default? It pays to know and understand what is in that section. And admittedly, in a lot of contracts, the default section is going to look like a big block of text. It's going to be a lot of words. It's going to be a part that you may or may not really truly understand, but it's very important in the contract. So if you're going into a contract and you want to negotiate that part, that might be a time too when you get your legal counsel involved. Another thing that you mentioned this earlier, Meredith, that people come to us and talk about are these capitalized words that appear sort of randomly around a legal document. Can you talk to us a little bit about those, what those terms are?
Yeah, for sure. So anytime that you see a capitalized word in a contract, you should know that that is a defined term. When we talk about defined terms, I think, a lot of people that are not involved in contracts usually are shocked at how many pages of a contract may actually be taken up with defined terms and how much time lawyers spend negotiating those definitions. So we wanted to give you an example today of some defined terms and why they're so very important. The first thing that we want to point out to you is that a lot of defined terms in and of themselves contain additional defined terms. So not only do you need to read the definition section and see, what this word means, you need to understand if there are words incorporated into that definition or even other documents incorporated into that section. Make sure that you understand how all of that traces through the document. So we're going to read you one sentence today, just so you can see an example of how many defined terms may actually be in a contract. And this is just, again, one sentence, one example. So I'm going to just read this to you, and I'm going to hold up my fingers to show you how many different defined terms there are. So, upon the terms and subject to the conditions set forth in this agreement, at closing, seller shall sell and deliver to buyer, and buyer shall purchase and accept from seller the interest free and clear of any lien. So I'm going to move my hands around here for you. 6 defined terms in that one sentence. So, and we can guarantee pretty much at least one of those terms is going to include other terms in its definition. So again, we want to make sure you understand anytime that you see capitalized terms, really pay attention to what the meaning is associated with that term. There may be defined terms in sort of the paragraph or the section itself, where there may be a whole section that has definitions. But again, these are really important. It's not just random capitalization. One of the examples of some of the negotiation that we enter into is for a term like knowledge. When we are talking about buying and selling businesses and we want to define the seller's knowledge of certain things, we negotiate, what kind of knowledge is this? Is it actual knowledge? Who does the knowledge extend to? Are there certain people in the company that should be in the know, or is it anyone that possibly could reasonably be expected to know something? So again, that's just, a few short examples of why defined terms are so very important. Another piece of contracts that is also very important is the indemnification language in a contract. Anderson, can you talk to us a little bit about that?
Sure. Indemnification is one of those things in a contract that not many people, reasonably understand. That's not something that you run across every single day when you're running your business, but it is important. And certainly when you're dealing with big transactions, you're buying or selling your business, it's really important to understand. So in the most simple terms, indemnification is stepping into someone else's shoes to handle something. So what I mean by that is, we'll use an example of selling your business. If you sell your business and you have a closing date when that business transfers from seller to buyer, there may be things that happened before closing that were really the responsibility of the seller, but the buyer ends up getting the burden of those responsibilities. They end up receiving notice from, the state about taxes that are due, or they get a notice from a supplier that there's an account payable that never got paid, or they receive a letter from somebody saying, hey, I'm going to file a lawsuit against you because of work you did. And the buyer realizes that was before closing. They had nothing to do with it. Indemnification is what will give that buyer the right to demand the seller to come and stand in their shoes and handle this problem. Handling the problem may be reimbursing them for attorney's fees if they have to go to court. It may be paying that account payable that comes due after closing. It may otherwise be the seller actually coming in and handling a problem and taking care of it. But where we see indemnification really matter is, how those terms are defined. Indemnification, again, just like the default provision, is going to be a block of text. It's going to have a lot of defined terms. It's going to have indemnified parties and third-party indemnities and all kinds of things that, just on a day-to-day basis, you're not going to be dealing with. So it's understandable that it's a confusing provision, but it is really, really important, because if you're the seller of a business, it is the thing that could continue after closing to be an ongoing responsibility that you have to the buyer to handle things. Indemnification comes up in non-transactional contracts too. It could be some kind of liability protection for a contract. If somebody says, look, if we do this work for you and we end up getting sued for something, you're agreeing to step into our shoes and either reimburse us for our losses, or if we end up with a judgment, to pay off that judgment. You're going to be responsible for the liability we're taking on by performing this contract. So you need to make sure you understand everything that universe of indemnification includes, because it's going to continue even potentially after all of the requirements of the contract have been taken care of. So it is important in that sense. You also want to make sure where the limitations are. There are boundaries to indemnification. If somebody is acting, grossly negligent, willfully, intentionally, in a way that brings liability about, even if there's an indemnification clause, there might be a carve out there that says, even if I've agreed to indemnify you against certain things, if you do something intentionally to bring about that liability, or you act so grossly negligent that no reasonable person would have done things that way, I don't have a responsibility any longer to indemnify you for that. So figuring out, what the monetary limitations are, what the legal limitations are, what the bottom, floor of when indemnification kicks in. All of those things are things that can be understood if you hire a lawyer to review your contract, or in a better situation, to actually negotiate those in the best terms for you if you hired a lawyer to negotiate the contract for you from the beginning. So again, that would be a place where we think, lawyers' involvement could be very useful. Another thing that we get a lot of questions about are all of the terms at the end of a contract. It sort of may fall under like the miscellaneous, or it's kind of, boom, boom, boom at the end of the contract. Meredith, talk to us a little bit, if you can, about what those might be and how they might be important to somebody who's entering into a contract.
Perfect. So we call all of those sort of miscellaneous terms the boilerplate. It's just sort of what we refer to them as. It does not make them any less important. Like Anderson said, it could be under sort of one heading of miscellaneous and have a whole bunch of language jumbled all together, or you could have some separate subsections that address these things. So we wanted to talk to you about why these things that may look like they're just tacked on at the end, they may look standard like you've seen in every other contract you've signed. Actually, minor variations can be very meaningful. So we're going to give you a couple of examples of terms that are usually included in the boilerplate language and things to look out for, or sort of why these terms are important. The first one is language that addresses whether the contract is going to be binding on successors and assigns. I know we've talked about buying and selling businesses. This is just another great example with buying and selling businesses, that if a business is sold and there's a contract that you want to be binding on the successor, you need to have language in there that says this contract is binding. That's pretty important to have in there. It's same vein, language that relates to assignments. So if you are the seller of a business and you've got a really great contract that it's going to help you get more for your business, if buyer is able to continue working under that contract, you want to make sure you've got the right to assign the contract. Again, there are variations here. You could have the right to just assign it. You could have the right to assign it with prior consent. You could have no right to assign it. All of these things are places that an attorney can help you negotiate those terms. Other language that's important is whether this contract is the entire agreement. So a lot of times people will say, well, we talked about this other term before we signed this contract. You want to make sure that other term is not able to be brought in because you've got language that says this contract is the entire agreement. We mentioned earlier, documents can be incorporated in one agreement. So you want to make sure you're clear about which documents might be incorporated. Again, that would be handled in this entire agreement section. Another one that's really important is language about waiver. So an easy example here is if you're a landlord and someone's supposed to pay you rent by X date, if they pay you 5 days late and you just let that slide one time, you don't want that to mean that you have to let it slide every single time in the future. So if you waive your right to say that that payment was late, you want it to only count as waiver of that one instance. And then the last one I'm going to touch on is another one that I think people sometimes sort of skim over, but is very important. So that's governing law and venue. You want to make sure you understand what law is going to apply if there is ever a dispute about the contract. State to state, you're going to see a lot of variation on, whether certain terms are, addressed in the law, and even how the courts are going to sort of construe the law. Is it going to be more favorable to the employer or employee, the plaintiff or defendant, et cetera? So it's important to know what law is going to control. And then venue, if you're like me, if you're ever involved in a lawsuit, you don't want to have to fly halfway across the country to go litigate that. You've already got enough expenses involved in going to court. So we want to make sure that the venue is somewhere that is going to be convenient for you. Not only that it's, a convenient location, but also that it's the most favorable venue possible. So those are, some things that are included in boilerplate that are really important. Now that we've talked to you a little bit about sort of, what happens to make a contract, what's required to be in a contract, or to make a contract enforceable, and some of the things that you should really look at, we're going to talk about a few examples of contracts that you would see.
Sure. So you had mentioned earlier I think when you first started about a letter of intent. We'll start there because it really is sort of the starting place for a lot of transactions. A letter of intent generally is a non-binding document that helps to lay out the major terms of a transaction before you invest the time and money into drafting the actual contractual documents that go along with that transaction. So it might be the buying and selling of a business. It might be a term sheet for a large goods purchase. It might be a lease, commercial, residential. Either way, it's going to have those terms like, the length of time it's going to apply, the amount of money that's being paid, some other terms that each party may think are very important. And the goal is to not run into those roadblocks later down the road. Like Meredith said earlier, you might have already agreed on the terms. You may have a term sheet or a letter of intent before you ever bring a lawyer in. That's fine. That is something, if you feel comfortable handling yourself, you can do it. You want to make sure certain things apply, like the fact that it's non-binding. So there is some risk in handling that without your lawyer. If you're going to have a lawyer go throughout the entire transaction, you might want to bring them in before you've signed anything. But that would be, something that you could potentially handle if you felt comfortable. Regarding buying and selling businesses specifically, I would encourage anybody who is in the market to buy a business or may have a business they're looking to sell. On February 24th, Wednesday, February 24th, there'll be a talk by a few more of our business attorneys talking about specifically buying and selling businesses. So 12 o'clock on the 24th of February, if you're interested in that topic, I'll go ahead and plug that right here. You can see a little bit more information about that. I'm sure they'll talk about letters of intent in that also. Meredith, what's another type of contract that a business or an individual might encounter?
Yeah, so services contracts are really common. We see these very frequently on both sides, whether it's the business providing the service or the business benefiting from the service being provided. And the key piece we want you to think about with a services contract is the definition of services. We have really harped on how important defined terms are. And this is one that you don't want to have to try to cram into a sentence or two in the contract. We like to suggest that you use a schedule or an exhibit and you really drill down sort of what are the services that are expected to be provided. If there are specific nuances about the services, make sure that you address those if they're important. We've seen a lot of folks use a bullet point list is totally fine. We just don't want you to be, crammed into not being able to specifically define the services. Another piece that's important in services contracts are what standard is required to be met. So when you're thinking about, as a personal example, when a package is being delivered to you, do you want the package delivered directly to you, or do you want the package thrown on your front porch, right? That's a different standard of care with delivering the package. So for your services, do you want the service provider to have to use their best efforts, or can they just use commercially reasonable efforts? That's one of the things that you want to think about in a services agreement. When are the services late? What if you're not happy? There are all kinds of examples of things that should be addressed in a services agreement. One of the biggest things that we've been asked about lately relates to services agreements in the context of the pandemic. Anderson, can you give us a little bit of information about that?
Sure. I will. We're running a little short on time, so I'm gonna hit on that, and hopefully we can get a little information before the presentation's over. One of the things we're getting a lot of questions about right now, and a lot of businesses are coming in wanting people to look over their contracts, is what's called force majeure. Force majeure means essentially an act of God, something that is not the fault of either party, but causes the contract to be different than maybe the parties initially intended it to be. That in the context of the COVID-19 pandemic, we're seeing that in businesses like surrounding the wedding industry, musicians, caterers, other people, planners who are working in that industry are saying, wait a minute, if there's an environment in which I don't feel comfortable, or there's an additional governor's order or other law that is passed after we sign this contract that materially changes the environment in which I was going to be doing this work in, how do we change or terminate the contract in a way that doesn't completely decimate my business, doesn't force me to pay money out of pocket? And we're seeing a lot of those kind of providers really across all of the industries that we work, being very careful of saying, what are the circumstances under which this contract can be changed or terminated as a result of something like a pandemic. I'll admit, before March of 2020, people were including things like the word pandemic in a force majeure clause, and nobody really paid much attention to them because when was the last time there was a pandemic? 1918. So we didn't really worry about it. And now those terms are of the absolute utmost importance when you're worried about those kinds of things. Now, one of the other examples that we were going to bring up, I don't think we have time to get into it in this presentation, restrictive covenants, we mentioned those earlier. Those are going to be things like non-compete agreements, either for a business that's being sold, an individual employee. There are very specific requirements that North Carolina law has for those to be enforceable. Certainly, if you're an employee who's going and joining a business and they want you to sign a non-compete, it might be time for you to consult with a lawyer to make sure it's legal, make sure you understand what rights you're giving up. And if you're selling or buying a business and there's a non-compete involved in that, I'm sure that the speakers on the 24th will hit a little bit on those restrictive covenants. They're a very normal part of buying and selling a business. Because I've seen that we've hit our time limit, and I'm sure without even looking that there's a multitude of questions in the Facebook chat. We will do our very, very best to go back after this is over and answer those questions as best we can in a non-specific way. If you have specific questions on anything we've talked about or anything else related to a contract that you need answered for you or your business, you should consult with your business's attorney, your personal attorney. The Van Winkle Law Firm is available. We have offices in Asheville and Hendersonville to function as your business's attorney or your attorney if you need an attorney. But those would be the people that you'd need to consult with your specific questions. We'll do what we can to answer general questions in the Facebook chat as they exist. But until then, thank you everybody for attending the talk, for listening. Thank you, Meredith, for your time and your insight. And we hope that you will all join us next week at 12 o'clock next Wednesday for the next in our 8-week series on business law. Thank you very much.